Perfect. Well, I think that's 2 minutes past 6, so we'll get started now. Well, hello everyone, and welcome back to our second Crammer. This time looking at general principles and police powers. And welcome to those of you that are joining us for the first time. Well, my name is James, and I'm one of the tutors at Police Revision. That's one of the leading suppliers of e-learning for police training and examinations. So as I said today, we're going to look at general principles and police powers, but just so I don't forget, at the end of last session, you asked me to rearrange the sexual offences seminar and bring it before the NIE exam. It does help from that, which we've done. And I think the new date will come at the end, but I'm pretty sure it's Monday, the 24th of February at 6 p.m. So normal time, but it'll be Monday, the 24th of February. And we've brought it before the NIE exam, but plenty of time for the sergeants and inspectors. Well, as I say, for those of you joining for the first time, everything that's going to be covered today in the curriculum is covered in the NIE, in the sergeants and the inspectors exam. Now, in the last session we went through a number of areas. We went through a number of areas looking at question format, looking at case law, and you gave some fantastic feedback from there. You really enjoyed the questions. So what we're going to do this time is I've listened to your feedback from there, and you said you enjoyed answering the questions. So I put a good few amount of questions in here for us to work through together and find those answers. And when you want to pick your answer, A, B, C, or D, feel free to put it onto the chat, and then we'll work through the offences and the case law and the information after. It's a really nice way of doing it from there. And you guys are fantastic. You were so good with those questions last time. So many of them got them correct from there, and it really, really was impressive to watch from that. But I've put a couple of tricky ones in here. I feel bad about one actually that I've put in here, but I'm sure you're going to be brilliant from there. So also, when it comes to future crammers from there, have a look. I think you're signed up to Police Oracle. From there, we have obviously the other sessions coming up. We have, I think, property offences, serious crime. That's fantastic. We look at homicide offences and similar from there. And then, of course, the sexual offences at the end. And I think for the NIE candidates, but of course, it can be attended by anyone in a couple of weeks. And Harry, our technical expert behind this, will let you know. We have the ABC of the NIE, which is an hour session, which looks at offences from A to Z around the NIE. And it's great fun. And we work through it, and we pack a load into that hour. And as you'll find today, as we do, we are going to pack a lot into this hour. And I'm going to try and make general principles and police powers and procedures as much fun as it can possibly be. And I think we'll all agree that's not easy at times. But it is a massive section, guys, for us to look at from here. So we need to pick only a few areas that really focus on, because I don't just want to skim the surface. I want to go into these areas a little bit. So I'm going to look at mens rea. We're going to look at actus reus. We're going to look at entry, search and seizure, and we're going to look at detention of persons in police custody. Now, a little bit of housekeeping before we come. Please try not to go on to unmute yourself, but if not, Harry's here just to rectify the situation. And when it comes to the chat bar, I'm not sure if someone can just put a comment on there to make sure that's working now for me. Feel free to put your answers on. Unfortunately, because the amount of time that we've got packed in here, I can't really stop for questions. But as you know, on the last session, I will have my email on there at the end, and I'm so keen to talk to candidates. I really am passionate about this. So if you have any questions about this or the last seminar from there, then of course we'll cover it. Any areas you're not sure about, that's what I'm here for, to cover it off for you. So it's going to work really, really well going forward. Well, we just wait for the last couple to come in for now, and then we'll start with mens rea and actus reus. So let's start looking at mens rea and actus reus. Well, let's start by understanding what we mean by these terms. Well, let's have a look and see what we can say from here. Well, mens rea is the state of mind of the offender, and actus reus is the behavioural. Thank you, Harry. And actus reus is the behavioural element of the offence. So in the most simple of examples, you can see the two images on the screen of the male walking up to the window. I make the decision to throw a brick through the window of a pub. That's my state of mind. That's my decision. I pick up the brick and throw it through the window. Well, that is my act. That's my actus reus. And we need these two parts together for the criminal offence. Now, there's two things to remember. Thinking about committing a crime is not enough. We haven't quite hit minority report yet with thought crime, so it doesn't quite hit about that. You have to have the act also, and the act must be voluntarily undertaken, and that's really the basics of mens rea and actus reus. So let's have a look at a couple of terms and concepts, as there are a good few associated with mens rea and actus reus, but the ones I really want to focus on this Crammer is intent and recklessness. Well, starting with intent, and this is meaning an intention for something to happen. Well, now we have those offences with intent. We looked at burglary 91A in detail in the last seminar, and GBH with intent. And once you add the term intent to it, it really adds gravitas to those offences. Or I've just seen the comments come on. I can't see the screen share. Just checking for people. Put me a thumbs up, or if it's all good now, you've come on. Ah, lovely. Harry, you got it from there. Just a couple of candidates, all good. Apologies for those that can't see it at the moment. Hopefully there's just a little bit of lag from there. Right, so we looked at intent. I said about that, really, intent really adds gravitas to it from that. However, we cannot claim that defendant intended a consequence of their behaviour simply because it was almost certainly going to occur. The circumstances will be put before a court for them to decide. Well, let's have a look at a little example. John throws an axe at Mark from a few feet away. The axe strikes Mark in the face and kills him instantly. John states he never intended to kill Mark, only injure him. Well, the jury will consider that there was a probability that throwing an axe in Mark's face would kill him. The probability of it killing him was actually very high. Therefore, there is a likelihood that John foresaw the death of Mark as a likely outcome. And if he foresaw the death of Mark from this act, then it's more likely that he intended that to happen. And it's the case of R.V. Nedrick, 1986, which is key, especially in homicide cases. In this case, the defendant Nedrick had a grudge against a woman, and in the middle of the night he drove to her house, poured petrol through her letterbox and ignited it. No one in the house was warned, and as a result, tragically, a child died. The outcome of this case was that the jury should be directed that they are not entitled to infer intention unless they are satisfied that they felt sure that death or serious bodily injury was a virtual certainty of the defendant's actions, and that the defendant knew this. But you know what? I've already been talking for 2 slides now, and I haven't listened to that feedback. So how about we try a question? Oh, Harry, I've just seen on the comments, I think a couple of people are trying to get back in. If you could do that and have a look for me. Thank you, everyone. Just take from there. Right, so here is our question. Aaron and Mikey, both 12 years old, are playing in an alleyway behind some shops. They find a box of matches and set fire to a set of old leaves and newspapers, pretending to be cowboys. Mikey's mother calls them in for dinner, and they kick the leaves and the newspaper under a wheelie bin, expecting the fire to extinguish on the cold floor. Instead, the fire spreads and causes over £1 million worth of damage to the shops. Aaron and Mikey are arrested, and both state that they were unaware of the surrounding risk and thought it would burn itself out. Considering the concept of recklessness, which of the following statements is correct? A. The risks surrounding the actions of Aaron and Mikey would be obvious to a reasonable person, and as such their actions would be considered reckless. B. Aaron and Mikey were unaware of the risk of their actions posed, and as such would not be considered reckless in these circumstances. Oh, look at you already getting these answers from here. C. Recklessness is considered on an objective basis. Aaron and Mikey not extinguishing a fire properly is reckless per se, and they'd be guilty of arson. Or D. As both Aaron and Mikey are over 12 years old, they've been expected to have foreseen the risk of not properly extinguishing the fire, and as such are reckless in these circumstances. Look at you all giving B there. Absolutely. That is the correct answer, and really well done to you there. I told you you're too good at this. You put the answer on there before I've even finished reading the question, so well done. But there's going to be some more trickier ones. You know, I like to start off being quite easy from that. But let's ask ourselves, why is this the case? Well, because of the case of RVG, you know I love case law, which has almost identical circumstances to our questions. Indeed, there were two boys aged 11 and 12 who, whilst playing camping, set fire to some newspapers and pushed them under a bin, which went on to cause over £1 million worth of damage. Well, they were convicted, but this was overturned. Why? Because a reasonable bystander may have been aware of the risk the fire posed when left, but the children did not. And this outlines that the interpretation of the word reckless will be subjective, meaning that each and every case will be examined individually. And look how fantastic you did there. So why don't we try another question then? Let's see if I can up it a little bit more. I'm not sure, because you're very, very good. Right. Well, I'll give you 90 seconds now. I won't read the question out for this one, but Mehmet is meeting Julia in a bar, and we're all around a chain of causation. So take your 90 seconds and work through it now. Good luck, everyone. Well, Neil, Stephanie, Fran, Tom B, and everyone else, you're fantastic. You're too good for me. You're going to be brilliant detectives, sergeants, and inspectors, whatever you're working towards. Absolutely right. You got the right answer. The answer was indeed A. Julia's rejection of a blood transfusion does not break the chain of causation, as if it were not for the stab wounds, she would not require a blood transfusion. Well, this question is based on the case of R versus Blau, 1975, which holds almost identical circumstances. Ultimately, the question asked is whether the victim's refusal to accept medical treatment broke the chain of causation between the defendant's act and her death. Well, of course, it was found that the stab wound and not the girl's refusal to accept medical treatment was the cause of death. The victim's rejection of a blood transfusion did not break the chain of causation, and the defendant must take the victim as they find them, and that includes any characteristics and beliefs, not just their physical condition. Absolutely fantastic, everyone. Right, but I'm gonna up it now from here. We're gonna have a little bit more at causal link. So the definition of causal link is the link between the act and the consequence. So I like to think of the causal link as a piece of elastic. At one end you have the act, in our example, the stabbing of Julia, and the other we have her death. We then have the blood transfusion hanging over in the middle of the elastic, but unfortunately for Mehmet, that is not enough to break the causal link. But the further apart we pull the elastic, the weaker it gets. So we can take from this that the further apart the act to the consequence, the less likely it is that the person is criminally liable. So what about the term intervening acts? The weaker it gets, so we can, what about the term intervening acts? Or, well, you're so brilliant. Let's use the Latin term from that. Novus actus interveniens. From there. So that means intervening act. Novus actus interveniens. Really going to impress your colleagues tomorrow when you talk about that from there. So really good. Use that, and we're learning Latin as well. Well, this means a new intervening act or an intervening act or an event that breaks the chain of causation. It breaks the causal link between an original wrongful act and its consequences. We are cutting our elastic bands. But the intervening act must be independent, free, deliberate, and informed, and in all seriousness, are fairly rare in police cases. But the easiest way to understand intervening acts is through a couple of examples. Well, no intervening act, well, we've covered that through our case law, very similar. A person is stabbed, goes to the hospital to be treated, and a medical mistake is made, or a major wound is missed, or the wrong wound is treated by an inexperienced medical staff, and the patient dies. So it's very rare that medical negligence will be considered as an intervening act. But there are such times. Well, what then will consider an intervening act? Well, a person is stabbed, is successfully operated on, and is well on the way to recovery when several weeks later they're administered the incorrect medication by the doctor, they have an allergic reaction and die. Well, we now have an intervening act. Why? Because the elastic is very thin. The stab wounds have healed, several weeks have passed, and the incorrect medication is what has killed them. Yes, they wouldn't have needed it had it been for this, they hadn't been stabbed, but the causal link has stretched far apart from the original act to the conclusion. Well, you're doing fantastically well. I should really do the next few questions in Latin, especially because you've all got the right answer. But I fear you would get those correct also. So why don't we try one more question around mens reus and actus reus, and then we'll move on. Oh, good question this about Stephen walking his dog alongside a local lake. 90 seconds, everyone. And as per normal, pop your answer on the chat bar. So how did you find that? Well, not quite 100% answer then. We've got a few C's and we've got a little handful of D's in there as well from there, but mainly C's and a handful of D's. So let's have a look at the answer. C. Stephen is not criminally liable for Carla's death. Now, although Stephen has failed to save Carla, he's undertaken no positive act to cause the death of Carla and therefore is not criminally liable for her death. Remember, a moral obligation is different than a legal obligation. Now, that doesn't mean to say that it wasn't an abhorrent act and it's an awful thing to have done, but it doesn't mean that Stephen is criminally liable. So does this mean that there must be a positive act, or can someone become criminally liable by omitting to do something? And that leads us on to omissions. Well, omissions or a failure to act can at times bring criminal liability. And when considering omissions, I really want you to consider the word responsibility. Ask yourself, does the person have some responsibility over their actions that's been undertaken? Now, there are a number of cases that relating to omissions, and I've included some of the key ones here. Now, the first one relates to a dangerous situation that has been created and not dealt with, and that's the case of R.V. Miller. Well, in this case, the defendant, who was homeless, had spent the evening drinking before returning to the property where he was squatting. He fell asleep with a lit cigarette in his hand, which started a fire. The defendant woke and, seeing the fire, took absolutely no steps to extinguish it, but simply moved to sleep in a different room. Eventually, the whole house caught fire, causing a huge amount of damage, and the defendant was charged with arson. Well, the court concluded that as he was responsible for having created the dangerous situation, the defendant was under a duty to take action to resolve it once he became aware of the fire. The defendant was therefore liable for his omission to take any steps to put out the fire or seek help from the emergency services or neighbours, etc. He was accordingly convicted of arson. Well, the second is even simpler. Someone who has a responsibility in law or occupation and fails to uphold it. A great example is that of R.V. Pitwood, a crossing keeper who failed to close the gates, leading to someone being killed by a train, or R.V. Dytham, where a police officer on duty ignored a serious assault occurring ahead of him that led to a man's death. He simply walked away. Unthinkable, really. By omitting to do something they're expected to do means that they could well be liable, or are very likely to be liable. And it goes back to that word, responsibility. And it's similar in situations of taking on the role of a carer for someone, perhaps an elderly family member or a child. You agree to take on the responsibility or an obligation for caring for them. And if you simply stop, such as failing to give a bed-bound relative food or medication, and they sadly or tragically die, then of course you could be criminally liable. So we've covered loads there around mens rea and actus reus, and your question answering was fantastic as it was last time. I need to make these questions harder from that, but we need to move on to a different area. So let's have a look now at entry, search and seizure. So entry, search and seizure, where we need to understand all of those wonderful powers you have to effectively police and investigate. Well, I tell you what, let's keep with what we're going to do now, and let's start with a question which you're all going to get fantastically correct because you're all brilliant, and will lead us nicely on to have a look at our powers. So, as I said before, 90 seconds, have a read through, and then please pop your answer on the screen. Well done, everyone. Right, I'm going to contact the College of Police in the morning. I'm bringing the exams forward to next week. There's no shortage of detectives, sergeants, or inspectors. You are going to sit the exam and you're going to absolutely blow away. Really well done, everyone. For those of you that got D. If you didn't, don't worry. Listen, that's what we're here for. We're here to learn. We're going to take it away from that each session. We've got loads of these sessions before the exams, and we're really going to work to get that knowledge. Really well done, everyone. Of course, the answer is D. If DC Hill and DC Langford reasonably believe that the recording or disclosing of their names could put them in danger, then they have a right to use a warrant or identification number and the names of their police station. So where do we get this? We get this from PACE, which outlines the guidance for legal search and seizures of property, and exactly 2.9. Nothing in this code requires the identity of officers or anyone accompanying them during a search of the premises to be recorded or disclosed in cases linked to terrorism, or if they reasonably believe it may put them in danger. Warrant numbers and the name of the station they're attached to should be used. And the key phrase is that they reasonably believe it may put them in danger. But unfortunately, there are times when you need to deal with organised crime groups and violent offenders, and protection needs to be put in place. No inspection authority is needed, and it's not just for terrorism cases, but likewise, officers cannot just make the decision on search warrants, oh, I'm not going to disclose my name. They have to justify it from that, as can be seen from 2.9. Well, let's have a look at that now at a little bit of key learning around entry, search and seizure. Okay, so Applications for a search warrant, section 15. Well, a warrant to search a premise on a single or on more occasions must be supported in writing and presented before the court. It needs to specify the name of the person applying for the warrant, the date of issue, the enactment under which it is issued, and each set of premises to be searched, or the person to be searched. Well, rules around the execution of a search warrant is covered under section 16. The warrant must be executed within 3 months of the application, unless of course it's a drugs warrant, then 1 month. And if an all premises warrant, any subsequent entry must be authorised by an inspector. And if present, a copy of the warrant will be supplied to the occupier along with other guidance. Well, an application for search warrant for indictable offences is section 8. Well, under section 8, a constable can apply for 2 different types of warrant, a specific premises warrant or an all premises warrant, which covers all premises occupied or controlled by that person. And the officer applying for the warrant must have reasonable grounds for believing that material that is likely to be of substantial value to the investigation of the offence is on the premises specified. However, material which is solely of a value for intelligence purposes may not be seized under a section 8 warrant. Now, legally privileged material, and we'll cover this a little bit further later. Well, this is essentially documentation or communication, for example, of a client to their solicitor in various legal matters. Now, it cannot just be seized under a Section 8 warrant. There are some examples of it in a bit, though. However, if legally privileged material was seized inadvertently, it would not render the search unlawful. Now, when I say it can't be seized under a Section 8 warrant, I'm sure a couple of you are shouting there about Section 50, and we'll cover that shortly. Now, there are times when special procedure material is needed to be seized, and as such, a search warrant or a production order can be applied for under Schedule 1 to the 1984 Act. Okay, well, you know from the start, I said I do really like my case law. You know that from the first seminar we sat in. And we really, my philosophy when it comes to case law is we need to extract the outcomes. So rather than working through each case, although I do love doing that, from that, I've just put 4 pieces of case law on the screen now, just where we can look at the outcomes from it. So Foster v. Attard, when police enter a premise lawfully, they are on the premises for all lawful purposes. So you're entering to arrest someone for something, you open that lounge door and you find a cannabis farm in there. Of course, you're still on there for a lawful purpose. Robson versus Hallett, once an invitation is withdrawn, officers will become trespassers and can be removed by force. And that's when you need to use your very quick thinking to make sure that you're no longer a trespasser. Snook versus Mannion, if an invitation for police to be on the premises is revoked, then the person needs to communicate that clearly. It's been held that merely telling the officers to F off is not sufficient. And R versus the Chief Constable of Lancashire, officers that failed to supply a copy of the search warrant to an occupant were obliged to return the property they had seized. And remember that when you're leaving documentation, it's got to be left in a prominent place or handed to the home owner. Well, let's move on to perhaps our favourite power, section 17 of PACE, which allows an officer to enter and search premises without a warrant for a number of reasons, and a whole host of reasons there are. I picked on there. So you can enter to arrest a person for an indictable offence. You can arrest someone for a section 4 public order, fear or provocation of violence. Arrest someone for an offence under section 4 or 163 of the Road Traffic Act, driving under the influence of drink or drugs and failing to stop when required to do so. Recapturing someone unlawfully at large, I'll cover that in a bit of detail on the next slide, or saving life or limb or preventing serious damage to property. Now, the officer must have reasonable grounds to believe that the person is on the premise in all cases except saving life or limb where the level is suspect. Of course, totally understandable, you're saving life and limb, so you only need to suspect the person's in there because you want to save them. Now, the power to enter and search any premises in the relevant police area for the purpose of saving life or limb or preventing serious damage to property can be conferred to a designated person under Schedule 4 of the Police Reform Act 2002. Right, so I wanted just to cover unlawfully at large, only because other candidates I've spoken to have got a little bit confused in this area, so I wanted to cover it off from that. So, unlawfully at large. When pursuing somebody unlawfully at large, we get guidance of this through the case of D'Souza versus the DPP in 1992. Now, this case law was around a patient who had a history of mental illness and was lawfully detained at a hospital for 72 hours. She escaped, and the police relied on Section 17 to justify entering the house to recapture the patient. Well, the outcome was clarification around the meaning of pursue under Section 17, concluding that the police were justified in pursuing and entering the house to recapture the patient. So take this away when it comes to Section 17. If you're pursuing someone, then it can apply to someone that has escaped from custody, or as in our case, someone subject to an order of the Mental Health Act. And the pursuit must be live. And by that I mean it's a lifetime job and someone is being actively pursued. Section 17 allows you to retake them. Right, we'll have a look at Section 18. We'll have a look at Section 18 and 32, and then we'll go on to another question shortly. I know it can be a little bit heavy. Unfortunately, that is the nature. So Section 18 of PACE should be something you're very familiar with. Involves an inspector authority to conduct a search. Well, an 18.1, inspector may authorise a constable in writing to enter and search any premises occupied or controlled by a person who is under arrest for an indictable offence if he has reasonable grounds for suspecting that there is evidence on the premises of that offence or another indictable offence connected to or similar to that offence. And 18.5, a constable can conduct a search before taking the person to the police station if his presence is necessary for the effective investigation of the offence. They must inform an inspector as soon as practicable after the search. Now, I've just plucked off what I've called exam points here, but they're little just facts because we've only got an hour, so I really want to cram as much as we can. So, exam point 1, Section 18 only applies to premises which are occupied and controlled by a person. Suspicion that they occupy or control is not sufficient. Exam point 2, the extent of your search is limited for what you're looking for. So if you're looking for a stolen television, you cannot search small drawers. And exam point 3, when a search is carried out under Section 18, and every attempt should be made to explain to the occupier the reasons for the search, and failure to do so means you could be resisted entry. Well, let's move on to Section 32. Well, Section 32 of PACE. Well, to search an arrested person where a person has been arrested at a place other than a police station, if you have reasonable grounds for believing that the arrested person may present a danger to themselves or others. You also have the power to search the person for anything that may be used to escape from lawful custody or which might be evidence relating to an offence. Well, if the offence is an indictable offence, the officer can enter and search any premises in which the person was when arrested or immediately before he was arrested for evidence relating to the offence. And R.V. Beckford shows us that officers exercising this power to enter and search under this section must have a genuine belief that there is evidence on the premises. Now, Hewson versus the Chief Constable of Dorset Police, the court did not accept a Section 32 to be used when the person arrested had not been in the relevant premises where he did not live for a period of over 2 hours preceding his arrest, and he was not a danger to himself or others. So some quite strict rules around 32. Moving on now to Section 19. Now, Section 19 is a general power of seizure, and the constable may seize anything on premises if they have reasonable grounds for believing that it is evidence in relation to the offence they're investigating or any other offence, or that it has been gained in the consequence of the commission of any offence, and that it's necessary to seize it to prevent it being concealed, lost, damaged, altered, or destroyed. You, of course, all know this. This is your bread and butter from there, and I bet your property cabinets are bursting at the seams, usually with property officers shouting at yourselves to get rid of property that's in there. Well, let's have a look now at a couple of exam points. Well, if the officers are on the premises with only the consent of the occupier and that consent is withdrawn, they must be given a reasonable amount of time to leave, but cannot seize anything as they are leaving. So you can't be told, right, I'm withdrawing that consent, and you start grabbing a load of evidence. Under 19, we're going to take it from there. Unfortunately not. You need to make a decision to how you can start getting those powers into action. Well, exam point 2, a power exists to require any information stored in electronic form and accessible from the premises to be produced in a form in which it can be taken away and which it is visible or legible, or from which it can be readily produced in a visible and legible form. And exam point 3. Section 21 of the 1984 Act makes provision for the supplying of copies of records of seizure to certain people after property has been seized. This can allow a provision for property to be photographed or copies made for the person who had control of it. Really well done, everyone, for not leaving. It's a horrible, wordy section when it comes to entry, search, and seizure, and you've done brilliantly. And I think as a reward, I think we should have another question, and we'll take some learning away from that. So here's a question all about DS Adams, and those that were just saying about that section 50. I expect the correct answer from yourselves. Good luck, everyone. 90 seconds from now, and we'll go through the answer after. You're all doing fabulously. Right, so I see an absolute host of A's. That exam is definitely being brought forward. I'm going to sit down tomorrow myself and make sure I'm writing far harder questions. So what we've got is seize and sift powers. DS Adams can still seize the cabinet, even though he reasonably believes it contains items that are subject of legal privilege, as it's not reasonably practicable to separate them at this stage. And of course, you're all right. There are times when materials must be removed from the premises to be searched sufficiently, and Section 50 of the Criminal Justice and Police Act 2001 extends search powers to seize material to be examined elsewhere. However, it must be the case that it's not reasonably practicable to search or sort it at the scene. So an example of Section 50 powers is basically our example, finding several filing cabinets with thousands of paper documents, of which some are believed to be legally privileged alongside those pertinent to the investigation. And it wouldn't be practical to undertake such a search at the scene. Pardon me. So when property is seized under Section 50 or Section 51, seizing items from a person search, the officer is governed by a number of rules. Initial examination must be carried out as soon as practicable after seizing. Due regard must be given to the interested party and opportunity of being present or represented during the search. Officers should consider reaching an agreement with the interested party for the examination. And finally, items and property not being retained must be returned as reasonably practicable. Right, listen, you're going to get this one, but let's have one more question and then we'll go back to the start and we'll test some other knowledge from there. Right, 90 seconds, have a read through, get it correct. We'll go through the information and we'll move on. Fantastic. Right. So I think a majority of A's there and a couple of C's, but mainly A's. And it is A. DC Bannister has had the application for the warrant turned down. It should not have been granted to DC Perkins as it had not been supported by additional grounds. I'll be honest with you, I actually called this question the walk of shame until my wife saw it and said, you can't call it that because there might be persons who've had a warrant turned down. So she'll tell me off for letting it down. But I took it away because there's nothing wrong. People have had it done from there. So what does Pay say? If an application for a warrant is refused, no further application can be made unless it's supported by additional grounds. So DC Perkins cannot return to court unless he has additional grounds for the warrant. Well, that's fantastic. Like, you're absolutely brilliant from that. We've had a really good look at entry, search and seizure, extracted some key points, and you've done brilliantly on the questions, hopefully simplified a few areas. So let's have a look now at detention in police custody. Okay, I knew you were going to get all the questions right now, so I do feel bad that I have put a question which I think could test you, but I'm most probably going to be wrong. So, detention, treatment, and questioning of persons by police officers, Code C of PACE. It's 101 pages of procedures. I've read it a number of times, and you need to know a big chunk of it for your exams, whether it's detective, whether it's sergeants and inspectors. But fear not, as I've said before, when it comes to that revision, it's about extracting those key points. So let's start with a question. Now, I hope you've all brushed up on your knowledge of dealing with citizens of independent Commonwealth countries or foreign nationals. So 90 seconds. Get your answer in, and then we'll go through it on the next slide. Okay, right. Well, how do you get on that? A little bit more mixed answer this time. Few B's, few C's, few D's, all coming up from there. I think A had just held it from there. This is a horrible question from there. I should have put it in Latin, really, actually, to make it fun. But those that have answered, really well done for trying this, guys. And I wanted to try a couple of questions, or a question really that dealt with a niche area. So the answer is A. Do not worry if you got it wrong. That's what we're here for. We're going to get from that. So the custody officer must inform Rick that he has the right to communicate with the Malta High Commission at any time and have them told of his whereabouts and grounds for his detention. And we get this answer through 7.1. A detainee who is a citizen of an independent Commonwealth country or a national of a foreign country, including the Republic of Ireland, has the right upon request to communicate at any time with the appropriate High Commission, embassy or consulate, and that detainee must be informed as soon as practicable of this right and asked if they want to have their High Commission, embassy or consulate told of their whereabouts and the grounds for their detention. Such a request should be acted upon as soon as practicable. Really well done of everyone that tried that question. It's very difficult, but that kind of shows. I just wanted to put it in there really to show the amount of information that's in there. You know, in PACE that we have to extract, and that's what we're here for, to take those key parts out of it. Really well done, everyone. Right, So let's have a look now at detention. With the strict rules in place for the detention, treatment, and interviews of persons when being dealt with by police. The police are governed by PACE, Code C, we've mentioned, which is a set of rules and guidelines covering the majority of circumstances around police detention. I think my memory says about 101 pages, I think I said earlier, is what it currently is at. Now, this Crammer is going to focus on the detention aspect because this is a huge area. So a designated police station, well, that is one that has sufficient facilities for the purpose of detaining arrested persons. And a person who is being detained must be taken to a designated police station as soon as practicable after arrest. However, an arresting officer who works at a non-designated police station may take the arrested person to a non-designated police station if the detention of them is for less than 6 hours. Lovely little question there you could write. You would have got it right, though. A person qualifies as being in police detention when he's been taken to a police station after being arrested for an offence, arrested at a police station, is detained there by a police constable, or has been taken to a police station after being arrested under Section 41 of the Terrorism Act 2000. Right, so let's have a review of detainees' rights in custodies and key points around them. So the first right is to consult the codes of practice. Now, any questions around this will likely be around unreasonable delays. So a classic question would be that Mark, who's been arrested for drink driving and wishes to carefully review the codes of practice before giving his specimen of breath. Sorry, Mark, that's an unreasonable delay. Give your breath and then we will have a look at the code of practice after. So, excuse me. The second is having someone informed of your arrest. When you have to call your wife or girlfriend or boyfriend, partner or parent to tell them you're having a really, really bad day. Well, if a person cannot be contacted, then two alternatives may be chosen, and any further attempts is at the discretion of the custody officer or OIC, so depending how friendly they are. Now, these rights apply to every move to a different police station. So let's just say you are housed in a custody suite, let's say Bath police station, and you decide you're getting moved for some reason. We'll say there's a flood at Bath. You're going to move to Chippenham police station, then you have the rights at the new station. And as we all know, juveniles must have an appropriate adult informed of their arrest, regardless if they want them informed or not. But what happens if you've been arrested for an indictable offence and there are concerns that contacting someone could lead to harm or interference with evidence, or interference or physical injury to people, alert others suspected of having committed an offence but not yet arrested, or hinder the recovery of property? Well, an inspector can delay that call. Finally, the final right is that of legal advice. A person arrested and held in custody at a police station or other premise has the right to consult a solicitor privately free of charge. So a couple of points. If legal aid is declined, the custody officer will ask the reason, why don't you want legal aid? But of course, it's up to the person if they answer. And where a suspect first requires a solicitor and then changes their mind and says, no, I'm happy to be interviewed without a solicitor, then an officer of inspector or above will inquire again into the reasons why and can give authority for the interview to proceed without a solicitor. Now, and like we had with the codes of practice with Mark cannot say, I'm not giving that specimen a breath until my solicitor arrives. So, do you remember in the first seminar, for those that were in it from that, we spoke about a superintendent, how he can delay, she can delay access to legal advice. Well, if they believe that the exercise of the right will, and it's the same as we had before, lead to harm or interference with evidence or interference or physical injury to people, alert others suspected of having committed an offence but not yet arrested, or hinder the recovery of property. Okay, right, looking at that. Oh, wow, where has the time gone? Okay, let's speed up and have a look at reviews of detention. You're doing well, everyone. I know it's not the most exhilarating. Serious crime we'll look at, as I say, it gets far better in the Crammers from here when we start looking at things like homicide, far more interesting. But we have to get through this. So, reviews of detention. Well, there is a requirement for detainees to have their detention reviewed post their detention being authorised by the custody officer. Now, the review officer will be an officer of at least inspector rank, not involved with the investigation. But this changes post-charge. And we all know from that, as soon as someone's charged, the review officer reverts to the custody officer. So when is the first review when they're brought into custody? Well, it's no later than 6 hours after the detention was first authorised. not at the arrival of the police station when detention was first authorised 6 hours after. The second review no later than 9 hours after the first, and any further reviews before charge at intervals of not more than 9 hours. Now, a couple of key points around reviews. They can be postponed for such reasons as the detainee is being interviewed. However, it must be conducted as soon as practicable and the reasons recorded. And persons in police custody not subject to statutory reviews, so perhaps arrested for a fail to appear on, should still be reviewed as normal. It's good practice around the detainee's welfare. But remember, if they're not subject to a statutory review, that can be conducted by, say, the custody sergeant at any time. So what about extensions? Again, we covered this in the first seminar, so a really quick reminder. An officer of superintendent rank or above who is responsible for the station may give authority any time after the second review to extend the maximum period the person may be detained without charge by up to 12 hours. Beyond that, well, we need to go to the magistrate's court and get a warrant of further detention should they grant it. And this can increase the further detention for a period of up to 36 hours. Now, it's important to remember the application for a warrant of further detention can be made at any time. And that application can be made even before the superintendent's review. So you could have a really serious case and you think, I need that warrant of further detention. Well, even before the superintendent has given his or her review, giving you those extensions, you can go and apply for that warrant of further detention. And just like we spoke about in the first seminar, where we spoke about how questions are formed, think about how you could have a lovely multiple choice question around that. Right, but if you want to go for an extension of a warrant of further detention, then it must be made before the expiry of the previous extension. All very common sense stuff. If you just think about it from there, it's just got to be applied for before the previous one has expired. Fantastic. Right, let's just cover some key points now around charging detainees. We'll just run through this very quickly from that and we'll move on to a couple of things. So the majority of cases need to be referred to the CPS to make a charging decision, and a consultation with the Crown Prosecutor should be undertaken as soon as reasonably practicable. And where the Crown Prosecutor is unable to make a decision with the information available, then the detainee may be released without charge and on bail if conditions are necessary. Once the OIC reasonably believes there is sufficient evidence to provide a realistic prospect of conviction, they will without delay inform the custody officer who is responsible as to whether the detainee should be charged or cautioned. But if the person is not in a fit state to be released, then we have obviously a purpose of welfare and it can be delayed. Now, a detainee may not be interviewed about an offence after they have been charged with or informed that they may be prosecuted for an offence, unless the interview is necessary for a number of reasons. And that could be to prevent or minimise loss to persons, to clear up an ambiguity in a previous answer or statement, or in the interest of justice for the detainee, to have put to them or have an opportunity to comment on information concerning the offence which has come to light since they were charged or informed that they may be prosecuted. So again, really common sense stuff. You're there to sort out an ambiguity to make it easier to progress the case going forward. Okay, so I'm mindful, hopefully you don't mind, we might just roll over a couple of minutes into past 6 o'clock, but I'd like to get this covered now. Let's have a look at strip searches and intimate searches, an answer that's areas that are often examined on. So what's the difference between a strip search and an intimate search? Well, a strip search is a search involving the removal of more than outer clothing, a visual search of a person's body, the sort of search regularly used for concealed Class A drugs. From that could be authorised by a custody sergeant. An intimate search consists of a physical examination of a person's body orifices other than the mouth. And an intimate search can only be authorised for a person who has been arrested and is in police detention and is far more intrusive. And I want to focus on intimate searches. So for an intimate search, authorization comes from an inspector who has reasonable grounds for believing that the person may have concealed on themselves, 1, anything they could and might use to cause physical injury to themselves or others at the police station, or 2, a Class A drug which they intend to supply to another or to export. The officer must have reasonable grounds for believing that an intimate search is the only means of removing those items. And B, if the search is for a drug offence, the detainee's appropriate consent needs to be given in writing. So let's have a look at some key points around intimate searches. So the inspector must have reasonable grounds for believing that the item is concealed and that an intimate search is the only way to retrieve it. It really is that high level believe from them. This is the only way to get it to retrieve the item. The knowledge and advice from a medical professional is vital almost immediately. And every effort must be made to negotiate with the detainee to hand over the item or allow it to be retrieved safely. And if that can be agreed with a healthcare professional assisting or present. Now, an intimate search may only be carried out by a registered medical practitioner or a registered nurse unless an officer of at least inspector rank considers this is not practicable and the search is to take place under paragraph 2A1 we just looked at, anything that they could and might use to cause physical injury to themselves or others at the police station, in which case a police officer may carry out the search. This, however, is a last resort. So in practical terms, this is somebody who has something on them which is dangerous, a knife concealed or similar, and it's really the last resort. They're going to hurt themselves, they're going to hurt others, and it has to be retrieved. Now, a search for anything that could might cause physical injury can take place at a hospital, a surgery, other medical premises, or a police station, and that police station element is the last resort. But a search for Class A drugs, which they intend to supply to another or to export, may take place only at a hospital, surgery, or other medical premises. So note how police station is omitted there and can only be carried out by a registered medical practitioner or a registered nurse. So no police officer for the drugs, but and can only be carried out at a medical facility. Okay, a couple of other things we're just going to cover now. X-ray and ultrasound scans. Section 55A allows a person who's been arrested and is in police detention to have an X-ray or ultrasound carried out. This needs, again, to be authorised by an inspector or above if they have reasonable grounds to believe, that terminology again, that the person may have swallowed a Class A drug and was in possession of that Class A drug with the intention to supply another. Now, the person's consent is required, and if they refuse without good cause, it may harm their case when it comes to trial. And if a juvenile is under 14, then only the parents' and guardians' consent is needed. If they're over 14, it's their consent also. And medical examinations such as these can only be carried out by registered medical personnel and at a medical premises. Right. I want to maximize this time. Let's just have a look at some key points, because I wouldn't forgive myself if one of these came up. So we haven't gone live. When a person is under the influence of drink or drugs, they're not automatically considered to be vulnerable unless there is other information present to suggest that they are vulnerable. Now, any person who appears to be under the age of 18 shall, in the absence of clear information that they are older than that age, be treated as a juvenile. A person detained under Section 135 or 136 of the Mental Health Act must be assessed as soon as possible within the permitted period of detention specified under the Act. The appropriate adult has no role in the assessment and their presence is not required. A custody officer can authorise a routine search and or strip search, but an intimate search must be authorised by an inspector. We've covered that in detail. A detainee has the right to compose a letter or make a telephone call, but they must be made aware that it can be read or listened to and may be given in evidence. A poster advertising the right to legal advice must be prominently displayed in the charging area of every police station. And females aged 18 or over shall be asked in private if possible and at the earliest opportunity if they require free of charge menstrual products. Girls under the age of 18 must be under the care of a female in custody, and personal needs relating to their health and welfare are covered, as we said, including menstrual products. Right, we're going to go through one more set of key points, and then we're going to try a couple of questions, and that will conclude the session. You have done it brilliantly so far. There is so much information. Right, so a solicitor can be removed from interview if their conduct is such that it's preventing the interviewer properly putting questions to the suspect. This could include answering the questions on behalf of the suspect. Removal of a solicitor requires authorization from a superintendent rank, and we covered this in our first session. Unless one's not available, then an officer of at least inspector rank, but they must report the removal to the superintendent. Remember, it has ramifications. Where a detainee has initially asked for legal representation but then change their mind and proceed without one, if the solicitor turns up at the police station, they must be informed of their arrival and whether they would like to see them. A juvenile should not be placed in a cell unless no other secure accommodation exists and a custody officer does not believe that it's possible to supervise them any other way. And if a complaint is made by a detainee in relation to their treatment since their arrest, or it's noticed they may have been treated improperly, a report must be made as soon as practicable to an officer of police inspector rank not linked to the investigation. And if it relates to an allegation of assault, then a healthcare worker must be called. And finally, no police officer or staff could administer or supervise a person medicated themselves, and only a medical practitioner can authorise this. If the medical practitioner is satisfied that further self-administration is required, then they can authorise custody staff in a supervisory role. Wow, that is so much information there. And the problem is we've only just touched on it, but I wanted to get it in, as I say, for that hour from that. Right, I tell you what, let's have a couple of questions, just 90 seconds each from there. Let's go through it from there, and then we can close it off and see what else we've got in the coming up sessions. So here we are. It's all to do with a Panico's rest period. Good luck, everyone. I'm sure you will do fantastically. Absolutely wonderful. Thank you for everyone that's answered that question. It's B. Panico's rest period can be disturbed to speak to the solicitor, and at the conclusion of this, should be allowed to conclude his last 6 hours. And we get this answer through Pays Code C, paragraph 12.2, that outlines that. And I'll just quickly close down. The detained person has a continuous 8-hour rest period, but that can be broken for a number of reasons. And one of those is B, at the request of the detainee, their appropriate adult or legal representative. Absolutely brilliant. You're doing really well. And you know what? It just makes it point that, the questions that I write from here, you need to know the knowledge to get it from here. And it shows you're picking up that knowledge and working it from there. And if we go back to the first session, when you hadn't started revising before, you hadn't covered it from that, there were so many more mixed answers, really going forward brilliantly. Look, I know we're over the time. Let's have one more question and then we'll cover it off. So 90 seconds again. Good luck, everyone. Last question, and then we'll go from there. Okay, well, a few answers there, Mick, from A and B, and I kind of can see. So the answer I've got is, as Marcus stated, he very recently took LSD, then he should be visited and roused at least every half hour. But I think I'm going to reword that first answer there, because you are quite right. If we look at pace from there, it doesn't say anything about that they mustn't go into a cell from there, but I can understand why you've gone towards that answer, some of you from there. Well, the answer is covered in 9.3 of PACE Code C, those suspected of being under the influence of drink or drugs or both, or of having swallowed drugs or whose level of consciousness causes concern, must, subject to any clinical directions given by the appropriate healthcare professional, be visited and roused at least every half hour. This does not negate regular visiting of the suspect in a cell and a clinical treatment arranged. Sorry about that, Onion News. The question states XC, not LSD. My apologies from that. Slight difference on there, so my apologies from there, but from there. So, and 9.13, whenever the appropriate healthcare professional is called in accordance with this section to examine or treat a detainee, the custody officer shall ask for their opinion about any risks or problems which police need to take into account when making decisions about the detainee's continued detention, and when to carry out an interview if applicable, and the need for safeguards. So really well done, everyone, from that. That has been a really, really good session, and you have done so well. We've worked through 9 questions from there, and I really hope you've enjoyed it. As I said, we've got a host of Crammer courses coming through the next 4 weeks, which we'll cover on shortly. Now, I'm not really going to do a sort of a big sale now. You know, I'm part of Police Revision from there, and we offer always from there 25% off with coupon UKCH25 from here. So if you wanted to sign up, we've got loads of exams on there. We've got loads of questions, loads of Crammer courses. I've gone through it before, but those new to you from there, we cover everything that comes up in the exam and really have a lot of detail from there. Just going through now, this is the page I wanted to lean on from there, because just before everyone leaves from there, just contact a Police Revision tutor. Now, although I work for Police Revision, and from there, I am so passionate about this, and I've been doing it for a number of years, that I really want you to be successful, whether you're going for the NIE, the sergeants, or inspectors. Now, I've got my email on there, info@policerevision.com, and I offer it after every Crammer course. If there is an area you're not sure about, it doesn't matter if you're a Police Revision subscriber or not, contact me. I will happily go through it with you. As I say, I really enjoy doing this, and the amount of candidates that I've helped over the last few years and through various sessions and stuff, it's fantastic to see them get promoted, sergeants, inspectors, chief inspectors, detectives, and doing an absolutely fantastic job. Absolutely brilliant from that. You've done really, really well. Please come to me for anything else. Now, I think the next sessions, if I click on here, right. Okay, let's just cover it off. So Crammer Serious Crime, we've got on the 12th of Feb. Is that next Wednesday? Okay, next February from that. So Wednesday, 12th of February, we have got that. And that's a great session. Obviously, everyone's favourite serious crime. We're going to look at the most serious offences. Then we have property offences on the 26th of February. And you might notice my edit I did at the bottom here, because I only forgot to add this about an hour ago. Crammer of sexual offences now on Monday, the 24th of February, 2025, 6 p.m. to 7 p.m. Now, like I said to you about the email from there, we've only just touched on general principles and police powers as areas like identification and interviews. And from there, look, if you find these sessions helpful, contact me. I will try my hardest to put on more of these sessions. If you say, look, I really want to go through areas like disclosure, I really want to cover from that, just drop me an email and say, look, these are the areas I'm not sure about, and I really will try and squeeze in some extra sessions from there. Now, my job going tomorrow is to sit down and make those questions a lot harder for serious crime. So don't get confident now. From there, we might even put some in Latin. Now you're on your way from there. So listen, everyone, thank you ever so tonight for coming and sitting down there. I know it's late. Some of you at work, some of you have finished work from there, and you're doing really well. Keep up the revision. Keep up the hard work. You're going to be fantastic detectives. You're going to be fantastic sergeants, fantastic inspectors, and I want to help you as much as I can to get there. Really good. A session on disclosure would be great. I knew. Do you know what? I looked last night and I thought to myself, let's put disclosure in it. I opened up my notes on disclosure and my head shook. But you're right. You are right, unknown user. I'm going to do this. Okay, I will put another session in and we'll cover disclosure. Just email me and say, these are the sections I'm not sure about, and we will put in another session that we can do. Now, someone said about, can you review these? Harry, I think you're online. I think you're recording these sessions, aren't you, from that? And I think candidates can play them back if they so wish.
Yes, we're currently recording this session. And so we can make it available upon request.
Thank you, Harry. Sorry, I didn't mean to do you from there. So, yes, email me. We'll put another session in. I love live sessions. Really good. Sorry about the LSD ecstasy question at the end. I'll change the wording on that one. Really have those. Interviews, question mark. Okay, so interviews, disclosure we want as well, and we'll have a look at that. Stick with me. Come to Serious Crime. I will put some more. I'll put another session in covering those bits. Email me at info@policerevision.com and carry on with that revision. Come on, let's get it. Let's get a load of exceptional marks. Great detectives, sergeants, and inspectors. Have a lovely evening, everyone, with your families and friends. And if you're at work, have the best time ever. You're a wonderful bunch. And I'll see you on Wednesday, the 12th of February at 6 p.m. for Serious Crime. Bye-bye, everyone.